two things I like to consider is it's not a conspiracy if it could be true, and separate drinking fountains were legal too at one time. Hey everybody. So as by the title, we're going to talk about Lance Gloor. I just got my freelance Gloor shirt from my friend Kerry Cannon, and so I thought it'd be a good opportunity to talk about his case, especially when I looked up my articles that I wrote 4 years ago on him, and the website's down. It's no longer around. And this is part of the problem that legalization growers face, is the narrative is against you. Let's face it. Let's be true. You're a bad guy. Why are we having plant limits when it comes to what's legal or not? This is ridiculous. It's redundant. It's arbitrary, as we've said before. So let's talk about Lance, and I'll talk about his trial that I witnessed. That was fun, and Kerry witnessed it too. So, by all means. So when you Google Lance, you'll come up with a bunch of pages. It's nice to see the top one in my feed is his mom's petition, and it's all about raising awareness, sharing stories. That's how justice is done in America. It's not easy. It's not slow. And we're going to get more into that. We're actually going to watch this appeal. All right. So then the next thing is the DEA narrative, or the United States Justice, the district attorney's narrative. He was owner of a string of marijuana dispensaries, convicted of drug trafficking. He had shops. He had stores. There were thousands of stores in Washington State. Only a handful of people got selected to be a contestant in this freaking game of judicial system. And in Lance, I think his downfall, as I watched the trial, as I witnessed, you had Washington State going after this guy. You had him harassing him. Washington State officials. There was an organization called WestNet. I don't know if they're longer around. It's an acronym. I couldn't tell you what it was because it was an article that's no longer around that I wrote. But WestNet is a joint collaborative force of local enforcement. And so, mind you, this is also in Bremerton area in the southern Washington, where there are military bases, and they also had naval law enforcement, NCIS, and I believe Army enforcement as well, and the DEA. So it was a joint force. So where does the money go? That's always the question, right? So this is one of the things about WestNet that's kind of questionable. They're harassing for marijuana, and that was the big thing. Is in southern Washington, you won't hear about this, but it was kind of a shakedown with law enforcement and people who were growing in medical days. There was everybody knew where the growers are at. It's just a mutual. This is not a crime, people, period. This is not a crime. No matter how many plants you have, it's not a crime. And I think that's the misconcept that people just can't get over their heads. Like, if I have 100 plants or 20 plants in my house, my backyard shouldn't matter to anybody, because a majority of that could be used for personal, and probably a small fraction of that, maybe profit. Who cares? Why are we? Excuse me. Sorry. Why are we villainizing people for profit? I thought this was America, capitalism. Correct me if I'm wrong. All right. So then on that search, the third dude is can do clemency. Them trying to do clemency for him. Next one in the searches is the Seattle PI, martyr or hustler. Now, I've only met Lance once or twice, personally hanged out. Nice guy. I mean, he was a young man at the time. A young man with a daughter who was going to college. Like, that's who they went after. They went after a guy who raised a kid and contributed to his family. Now, he had good times. He enjoyed spending money and having a good life. Who doesn't? And that's what our judicial law enforcement went after? They went after a prosperous American. Correct me if I'm wrong. Sorry about that. All right. So, and again, martyr hustler. This is the one where the medical versus recreational debate, right? We're doing it for the people, but yet, why can't I feed my kids while at the same time? Or why can't I pay the electric bill? Or this whole nonprofit masquerade that we've been doing, which it hasn't been for a lot of people. Respect to those people who do it, and respect to people who make money out of it. I don't care what your deal is. If you're standing for the plant and you're standing for, like, this is a legit business, you're standing for the right side. That's it. Recreational medical, if you're or nonprofit. Let's just call that nonprofit versus profit. This is all we're really debating about, and it shouldn't be a thing. If I wanted to grow and give it away, it shouldn't matter to you. The only person it matters to is the guy trying to sell it because he wants money. Anyways, it doesn't matter. Quality will always find its way, I think, in a capitalistic market, America. All right. So finally, we can get to Lance's website, One Dream, One Team. This is all about sharing people's stories, sharing the wrongness in America. This is America's cancer. This prohibition. This is America's blind spot of judicial right and wrong. This is where we become the better. All right. So Lance's website, you can get a t-shirt. Look at that handsome devil. How to write Lance. Say hi to him, man. Look, here's his address. He's in Sheridan, Oregon, man. And I believe his mom still hasn't seen him after 4 years. So again, they're separating him from his family and they're keeping him away. It's like not only you're incarcerated, but you're in solitaire. You're in your own solitaire because you can't speak, touch, feel the ones you love. I don't think the poor guy's seen his daughter in 4 years. All right. So let's go to the articles that I wrote. Oh, look, there they are. So unfortunately, and this is no conspiracy. This is just a fact of how cannabis, marijuana, activism doesn't pay versus media and profits, and the message versus pretty much it. Like, I've been doing this for so long. I really am about the message. That's why I'm doing this video on my extra. That's why I try and use my time. I speak. I don't speak in public so much because it's hard. You get emotional. But I try the writing. I try to do everything I can to help every single one of these guys. Lance isn't the only one. Lance is just one of thousands. And that's part of the problem. As long as prohibition exists, so does the imbalance of justice, this racial and morally imbalance that we have out here. And that's why I've been fighting for prohibition. So again, pro-legalization websites and media and messengers, it doesn't pay. So here, this is toesignals.com. Steve Elliott, who's been a longtime activist. He's been a part of many things. Before Toke Signals, he was part of a website called Toke of the Town, which was like a go-to for many. It still is, but it got bought. And of course, the sellout concept and all this shit, plus loyalty to Steve Elliott, a lot of people still have. He's a nice guy, though, too. I mean, he's just another activist, human being. That's the thing. We're all humans. And that's what we need to get across, too, is when we go through Lance's appeal, pay attention to the prosecutor, pay attention to the judges. These guys are all just people. They're just humans, people who take showers, take shits, go to work. That's their work. And it's your right to speak up and talk to them. It's your right to let them know how you feel politically. Isn't politically and law the same, right? Couldn't you? And that's why court support is so important. And that's why I was so fortunate enough to be at Lance's trial for court support. The judicial system is not made for employed people. And I was fortunate enough to get unemployed right before his trial. And so I decided to spend my time, besides looking for a job, supporting him as a citizen. Because that's the most important thing that we have as a citizen is to voice. Our voice, our vote, and our time are the most important things that we have. And Lance has already lost 4 years of his time, 4 years of his kids' time. So yeah, I spent my days I could at Lance's trial, and this is where it gets fun. So, so back to toke signals. He just wasn't making money. He doesn't pay the bills. You can create a website, have a nice following, but unless you get support, that's why Patreons and all these other things are things. There's people out there with money with Patreons. Like, all right, guy. I mean, but I understand because the entertainment, the media, the interaction, this doesn't pay. And I'm not asking for anything yet. Don't bother me. But just let you know, it's how it is. That's why there's this imbalance of information as far as the right and wrong and whatnot. So check this out. Project PC was another person that was there, and they did some good documentation. Man, I really wish I had the documentation I did for Lance on toast signals. Though I wish I kept it written. There was many things besides the Westnut revelation. There was a DEA undercover who testified. He walked to Lance's store and was turned around right away because he didn't have a script. And so all medical dispensaries at the time had recommendation places you can go to. Some are in business together, some are not. Whatever. Scratch my back, scratch yours. Anyways. So this guy goes get a script. He's a big dude. This guy was like 6'6", probably about 280. I mean, clearly not a healthy man. Could easily have gotten it for high blood pressure, bad back. I think he got his for pain, something like that. And then went back in the next day or whatever following week, and was let in because he had a Washington State medical prescription, and that's how it went during Washington State during these days. The lack of regulation was the thing that killed him, but the lack of regulation was not a patient registry. It was more of there was no cohesiveness. Like, I had my script that was recognized in most places, and then a lot of times places would call your medical facility to find out. So that could have been a farce too. There could have been many things, but there were some databases, but they weren't cohesive, and that was part of the issue for medical. So Lance had multiple shops. Anyways, this guy testifies that he goes into one shop and he was happy. He actually made like a sexist remark about how like Lance hired all these pretty girls, these hot girls that made him feel good or whatever. I wish we had the transcript. And then he commented on how so he went in several days for a couple months undercover, making technically illegal purchases in the state of Washington at the time. Then he also commented too how the men in the facility went on days that he went in. I don't know why this guy brought this shit up, but he commented how the men made him feel unsafe, like it was unsavory, like all these tattooed young guys. But then on other days, all the hot chicks. No shit testimony given by this guy. So, mind you, this guy is a Washington State trooper, I believe it was. Washington State law enforcement. But he made all these legal purchases the legal way, and that should have been the end of the case. Like, we're done. Like, there's 1,000 other dispensaries where people are getting all their weed the same way you're doing it. At least you're trying the best to be in checks and balances. Lance's pot shops were even they had food drives and warm coat drives. They were participating in the community. Okay, so that's one shitty testimony. And then it turns out too, because they all explained how their investigation went. The law enforcement who testified that they handed over the evidence to the DEA. So the DEA, being that they are the federal police, have a moral obligation to go after Lance, and so they did, and was a downfall of Lance because he had to face the federal side of things. But let's talk back to what he was doing in the state side. He was running multiple pot shops. Who cares? There's people running multiple pot shops now. He was running pot shops in accordance with everybody else. And he was not doing anything above and beyond. He wasn't even doing out of state. When he didn't want to get so Lance was I hate to say out the word on the run, but let's call it what it is. I mean, I don't want to go to jail, right? So he left, went to Vegas, while still running his businesses in Washington State, or at least funding or whatever. But there was no interstate shipments. There was no cartel. Even his ex-girlfriend, who was, this is another fun fact. So I wrote, every day I was writing an article. And the one day she testified, and she testified that, Lance had some stuff shipped to him, but it was more like cookies and an eighth. This is all personal. He wanted to get good weed. New Washington had good weed. I think I referred to her as a Puerto Rican Barbie or something. I forget what it was. Anyways, I wrote about her article, talked about her. She was kind of like the showgirlish type, floozy nightclub chick. And, Lance has a type, whatever. But she brought in my article, printed out. And my article was entered in as state's evidence. Because she wanted to know if she could sue me. And she couldn't, because I just wrote everything that I saw, and the opinion of her appearance is my opinion, whatever. But I thought that was funny. And another fun note on Lance's trial: he was prosecuted by Vince Lombardi's grandson. Yeah, the same Vince Lombardi who's a football, legend, whatever. So, okay, and then also, and this is why we're here at Project PC's video. During I think it was day 3. Let me see if he mentions it in here. No, it doesn't say what day. But here are dead links to the articles that I did write, 2 of them. And so check this out. Project PC, thank you for documenting this. You helped me refresh my memory. So here's let's go back over here. I mean, honestly, the court support to me was one of the best things I've ever done. It was the most educational. So here's Lance. And it was the most eye-opening. And that's all his family and some activists in Washington State. Majority of it's his family. A bad, I would say an asshole doesn't get support like this. But so and here we are trying to raise support for him, the court support. So I'll read to you. Jury deliberation began yesterday for the trial of Washington dispensary owner Lance Gloor. Today, deliberation was disrupted after one of the jurors had to be taken from the courthouse by ambulance. The juror is a medical marijuana user. After 11 hours of deliberating, she began to have an anxiety attack and desperately needed to take her medicine. While cannabis is legal in the state of Washington, federally it's not. The trial is happening in a federal courthouse. This means she would have had been forced to break federal law in order to use her medicine on the grounds. The judge seeing the case had to call the hospital. Paramedics ended up removing the woman from the courthouse by gurney. She was then placed into an ambulance, at which point it is believed the woman was taken to the local hospital. Now the court is adding a new juror, which means the deliberation process has to start over. Between getting the new juror caught up in the case, Monday being Martin Luther King, Tuesday must be the soonest. So he doesn't mention it in his article. That was by Miko Hayes. Oh, I didn't know he was there. But check this out. So this poor girl was a medical marijuana patient in a medical marijuana case and passed out because she couldn't have access to her medical marijuana. And it was just another irony of his case. Now here's where I really think we should talk and keep our eyes open. So in this appeals case, they're seeking that Lance never got the chance to do the affirmative defense, which in my opinion is correct. He never got to prove that he was in accordance with state law. He never got to prove that he was doing the same thing that everybody else was doing. And let's give it a listen.
Honor. May it please the court, Cynthia Jones for the appellant Lance Gloor. I would like to plan to reserve 4 minutes for rebuttal. The issue before the court today is whether Mr. Gloor is entitled to an evidentiary hearing to determine whether the 73 plants at issue here were in compliance with Washington state law. And the answer here is yes. In this court's decision in McIntosh, in a series of consolidated cases, there were 30,000 plants at issue in one of those cases, and this court remanded for an evidence.
So what we have here is, in the beginning of her argument for the appeal and for the affirmative defense, she's saying the plant amounts matter. And that was one of the things that we're doing in Washington. There were several ways that people were doing the collective garden model. Some were you walk into a store, you sign up, you're in and out, you were part of that club while you were there. Others were you can only come here or we're going to represent you as we grow. So there were different ways that people were doing this. And this is why she's arguing about the amount of plants, because Lance was doing it a certain way.
Hearing. In Sokutsube, which is an unpublished case but persuasive, there were 1,000 plants at issue. Here, there are 73 plants at issue, and this court should remand.
Well, does it really determine on whether he's entitled to an evidentiary hearing? Does it depend on the number of plants that are at stake?
I think the number of plants is instructive.
Why is that significant?
When you look at Washington law and how the appellate court in Marquardt said a provider can grow for more than one patient. And under law, each patient is allowed 15 plants. Mm-hmm. Now, if you bear that out into Mr. Gloor's case, he would like at an evidentiary hearing to show a colorable argument that he was providing for at least 5 or more patients, which would put him squarely in the 15 plant per patient under Washington state law.
But doesn't the record nullify that argument? We already have a trial record.
All right, this dickhead. I mean, Your Honor, I know I do mean you're a dickhead. Because this gentleman here, his argument throughout most of this is, don't we already have a trial? Don't we already have all this on record? Didn't this? But the thing was, it was slanted. The justice, the perception of this trial, of Lance actually having a chance to prove that he was in accordance with Wash State, didn't really happen. He wasn't. This trial didn't prove that he was this cartel Rico guy. It proved that he had a dispensary just like present day, like pot shops here in Washington State presently, recreational pot shops. You'll hear the prosecuting attorney, or whatever they're called when they are against the appeal. He tries to argue that he would never got a license. That's just, he's making shit up. You don't know what could have been happened or would have happened if Lance wanted to go recreational. So let's dig into it.
That seems to show your client is neither a collective garden or a designated provider. Isn't that clear from the record that's already been created, and how will the hearing change that?
The hearing would allow Mr. Gloor to bring forth some evidence that he was in compliance with Washington state law. I think here, if you'll pardon the expression, I think the district court, in granting a motion in limine barring Mr. Gloor from bringing any evidence of compliance with Washington state law, was putting the cart before the horse. We still have...
I would like to argue too, when you use words like um, "don't we already have it here" or whatever like that, we're talking about a man's life. We're talking about a man who's already served 4 years and has got 6 more years pending for something that's recreational and legal in what 11 states, in our nation's capital.
Not had an evidentiary hearing to show whether or not, considering all of the evidence in an evidentiary hearing, he was in compliance. And under state law, I think what's really important to note is Washington mandates that when you're looking at the sufficiency of evidence for an affirmative defense in medical marijuana, the courts must construe the evidence most strongly in favor of the defendant. Here, the district court didn't allow any evidence of compliance with Washington state law. And further, one more note under state law. In State v. Constantine, the appellate courts instructed Washington litigants that a provider does not have to show that a person that he's providing marijuana for has a specific ailment for that medical marijuana. All he has to show, in essence, is that there was a doctor's note that that person has been diagnosed, and then they can provide the marijuana.
This case is a little bit different than McIntosh and Slutzeberry. Not sure I'm pronouncing that
So
correctly.
Kutzebe, I believe.
Slutzeberry.
Mhm.
Because they didn't have a trial in those other two cases. And here we have a trial record.
Again, the trial was full of shit. As I sat in the trial, the testimony given, evidence based, should not have led to Lance's prosecution because he was in accordance with Washington state law. The law enforcement officials investigating him should have stopped at a certain point instead of handing evidence over to the DEA. You could have arrested anybody now, anywhere, based off what Lance has been prosecuted for. I can go to Oklahoma right now and arrest a bunch of people. I can go to Pennsylvania. I can go to California. I can go to New Jersey, New York, Massachusetts, anywhere, and arrest Lance for what he was doing, which was following state law.
Isn't that right?
That's right. I think the
They
similarity.
didn't have it. They didn't really have much, especially in McIntosh. McIntosh was the very first case that dealt with the Section 538.
I think the distinction is a procedural one. In Kutzebe, they had pled guilty to the Title 21 offenses without waiving their right to appeal. And there had been some preliminary pretrial testimony below and issues there. I think here where we have a conviction like Kutzebe, there's a conviction with a bar of allowing the defendant to show any evidence of compliance with Washington state law. That's what makes this case different. I see that I'm near my time for rebuttal. Are there any more questions from the court before I reserve the rest of my time?
No.
Thank you.
Dun, 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 dun. This dickhead. So shiny.
Good morning, Your Honors. May it please the court. Michael Morgan for the United States. Assuming that compliance with the Washington affirmative defense would satisfy McIntosh, which is an assumption the government
This is something you're going to hear about more and more when it comes to legalization, and that's the affirmative defense, and that's what all medical is based off of. As Tom likes to say, you know, a crime without a crime? No. Shit, man. Never mind. But anyways, I want to do a crime, but yet, excuse me, I mean, this shouldn't be a crime. This is the blight in our judicial system and our justice system, and this is why I've been fighting for over 20 years. We're fighting a racially based law, not a scientific based law. This is why Black Lives Matter.
disputes, but taking that assumption for right now, the record provided in the trial proves conclusively that the defendant did not qualify for the affirmative defense with respect to the grow operation because he refused to provide documentation.
Okay, so I believe this guy muddies the water because in the beginning, like I said before, Lance took off. It was like, I don't want to go to jail. And unfortunately, things worked out the way they did. But during the trial, they were saying, look, we're a medical marijuana place. Like I said, the undercover tried to get a script or try to get in and couldn't get access until he got, unfortunately, we are in this nation of workarounds. And he found the one that was like everybody else was doing. So Lance is in jail for doing in accordance with what everybody else is doing, which is pretty fucked up.
When requested by law enforcement. That is a statutory prerequisite for the affirmative defense. Failure to produce that precluded
The records of the buyers, not the buyers, but the people who came into.
What he was required to produce was, quote, valid documentation, which is copies of the patient's authorizations. Even assuming that he
didn't need the patient's authorizations. In Washington State, they were just doing it as simple as having to sign in. It was up to the patient to prove that they were a medical patient, not the dispensary.
Trying to grow multiple plants for multiple patients, when confronted by law enforcement, law requires him to present those documents to law enforcement. Law enforcement specifically asked him, it's on page ER 390 of the record.
This is at the time of his arrest?
Yes, this was at the time of his arrest, and he had been given Miranda and waived. And he specifically was asked, do you have the documentation for a medical marijuana grow? And he refused to provide it. He didn't even answer. He just smirked.
Did he later turn it over? Did
No.
he later have it?
No, there's no evidence that he ever had it. But the fact of the matter is, even if he did have it, failure to produce it precluded the affirmative defense. So he had no affirmative defense as to the manufacture count in count 3. And as we know from this court's decision in Kleinman, if there's a count that is not precluded by the rider, because it's a count-by-count analysis, that count stands. And since concurrent 120-month sentences were imposed on counts 1 and 3, if count 3 stands, that's sufficient to affirm the judgment, even if there's an argument about whether or not count 1 is rider compliant. That was the exact situation that the court had before it in Kleinman. So given that there's no affirmative defense to count 1, or to count 3 rather, that is in and of itself sufficient to affirm. There's also no affirmative defense to count 3 because, 1, on a single day in 2011, he possessed far more than the minimum or the maximums permitted under Washington law to qualify as a collective garden. That's clear in the record. That was the seizure. There's no evidentiary hearing that's going to change the amount of marijuana that was seized. So there's just no need for a hearing in this case. And I should point out that the defense has kind of mischaracterized slightly the district court's in limine ruling. All the court did was say, I'm not going to allow you to argue that compliance with state law is a defense to the federal charges. Mr. Gloor was free to present and did present any evidence he wanted with respect to how his business is operated. In fact, the ruling specifically says, quote, the court expects the parties will present evidence that Gloor was operating a purported medical marijuana dispensary. So he was free to present whatever evidence with regard to his operation he wanted. He just wasn't allowed to make the legal argument. So he had.
So, look, I have a dispensary. It's a medical marijuana dispensary. You're still bad. You're still guilty. Even though you just told me everything. Like, this marijuana is not a crime.
Had his chance to try to prove that he was in compliance. He didn't. And he couldn't on this record.
Did the record establish it was a for-profit venture?
Here we go. This is where he asked about if the record establishes it was a for-profit company or whatever. That shouldn't be an issue. Profit versus non-profit. Does that fucking matter? It's a plant. No one's died from it. It's illegal because of racially charged testimony. There's so many reasons why this shouldn't be happening, but yet our judicial is not morally obligated. They keep chasing this legally obligated bullshit, but there's a morality that reflects us as Americans, as people, as cannabis consumers. When I went to go test or to support Lance, people were asking me not to and telling me all kinds of crazy stories. But when I went there and I watched it, there was nothing but cannabis being presented in this trial. Lance was prosecuted for being a young, flashy dude that lived a good life. Period.
Sure, and is that then precluded from
It-
state law?
It did. Mr. Gloor's partner specifically testified that this was a for-profit venture, that he made over $1 million running the dispensaries. Several of his employees testified that these, quote, donations, unquote, were really sales transactions. The employees testified that they weren't actually growing any marijuana. They were obtaining the marijuana from wholesale suppliers. That's precluded from being a collective garden. Collective gardens aren't even allowed to sell, quote, cannabis products. The collective garden statute at issue allowed only plants and usable marijuana. So all of these gardens, to the extent that they sold anything beyond plants and usable marijuana, were non-compliant. I mean,
Just
Every cannabis dispensary at the time was selling brownies, gummies, drinks, infused toothpicks. Where do you think half the shit you're smoking or eating or consuming now came from? It came from people during medical time who were trying to help patients consume without, because not everybody smokes. Let's get it through, people. Not everybody smokes weed or smokes flower, but they like cannabis. They like THC, CBD. They have an endocannabinoid deficiency that they need to help to make their days better. And these motherfuckers want to argue about whether it's profit, non-profit, too many plants. It's not. None of this should have been a crime.
Just out of curiosity, under today's state of the law regarding legalization of marijuana here in Washington.
All right, and that's here's the fun part here. Let's rub the magic ball here. We'll rub the magic ball with my pointer
Would his conduct be
because he's about to tell his future.
legitimate today? Would be lawful today?
it wouldn't be lawful today because they don't have the licensing. I mean, if he would qualify for licensing and he complied with all the licensing and regulatory requirements, it would be. But since he was never licensed, obviously you can't run a dispensary in the fashion that he ran today and have it be legal because it wouldn't be licensed.
Mr. Morgan, could I ask you to clarify one point on your theory? When you say an evidentiary hearing wasn't needed here, are you saying it wasn't needed because it's not required? Or are you saying that it's not needed
Well,
because of harmless? Because even if one's needed, it's a harmless error in light of the other evidence in the record.
what
I would like to take note when words like harmless are used, harmless error are used during a cannabis case or a just to make it passe. We're still talking about people's lives. This guy says 6 more years left. There's no harmless errors.
What I have been arguing is essentially that it would be harmless, conceding that compliance with the affirmative defense would constitute, quote, strict compliance within the meaning of McIntosh. The government actually disputes that point. McIntosh itself defined authorized conduct as conduct that if the state does not allow for prosecution. That's the actual language in McIntosh on page 1176. If the state law allows for non-prosecution, it has authorized the conduct. Washington law never allowed that. Washington law, at the time relevant here, allowed only an affirmative defense. The Washington Supreme Court has clarified that at the time period at issue, the possession, sale, distribution of medical marijuana was a crime in Washington. It was always a crime. It just admitted of an affirmative defense. Conduct that admits of affirmative defense, by definition, can't be authorized because you can't authorize someone to commit a crime.
So these assholes with affirmative defense, this asshole is saying, look, it doesn't matter if you have affirmative defense. Affirmative defense is bullshit. Even though you're an American doing something uncommon most Americans are doing and agree with you in, you're still a bad person.
It's conduct that is excused. There's a legal excuse for it, but the state is free to prosecute the defendant for that conduct. And under the definition.
And again, The state didn't prosecute him. It was federal.
Definition that the court adopted in McIntosh, that means that conduct was not authorized, which means the rider was not even implicated, and for that reason, a hearing was unnecessary. But the court
It's
doesn't.
probably fair to say, though, that if McIntosh had been on the books at the time he moved to dismiss,
No, McIntosh was on the.
at the time
Oh, no,
at the time he moved to dismiss
No, I apologize.
pre-trial?
No, you're correct, Your Honor. McIntosh didn't come out until after, it was the motion for reconsideration of bond. You're correct.
I suspect that if it had been on the books, that the district judge probably would have granted him an evidentiary hearing at that time, prior to trial.
I don't know, Your Honor.
Well-
I would say not. I think Judge Layton was well aware, because we.
So he can tell you that Lance wouldn't be qualified for a recreational license, but he can't tell you if the judge would give him an evidentiary hearing. Yeah, sounds like your fucking magic ball is broken, buddy.
Made this point in opposing the rider initially.
Layton didn't have the advantage of McIntosh at the time.
No, I
he ruled
understand.
On the motion to dismiss, and the time, you know.
No, I understand, but I think our point is that whether or not a hearing is necessary, could he have ordered a hearing out of abundance of caution? Sure. But there's also the very real chance that the court would have read McIntosh as the government has, which is that since Washington hadn't legalized marijuana, the rider wasn't implicated. And we did present that argument to the judge, so it was before him. But in any event, the court really doesn't need to go down that road, because you can easily affirm on harmlessness, because the record has developed, makes clear that the defendant was non-compliant and could not, as a matter of law or fact, establish the affirmative defense he would have needed to either count. Unless the court has any other questions, I'd ask you to affirm. Thank you.
No questions here. Thank you. Ms. Jones, you've kept some powder dry for rebuttal arguments.
Thank you. Thank you, Judge Gould. I'd like to address the argument of the government that the rider doesn't apply or isn't implicated because medical marijuana was not legal at that time. I have 4 points to that. First of all, Congress clearly included Washington State in the enumerated states in the rider that has to do with states that are trying to implement medical marijuana laws. Second, there are no cases interpreting the congressional rider that supports the government's argument. And finally, the significance of the state Supreme Court case that the government refers to, which is State v. Reese, that said, as the government reads it, that says medical marijuana is not legal in Washington. What that case was actually saying of significance is that a defendant cannot bypass an evidentiary hearing to bring forth his affirmative defense. And what Reese was trying to do was bring a motion to dismiss before he had brought forth evidence of an affirmative defense. That is exactly, precisely what Mr. Gloor is asking the court to do here, is to give him the opportunity of an evidentiary hearing so that we can figure out if he was in compliance with Washington state law.
But you already have a record. I mean, I don't want to go over this again, but you already had a record. You have a record here where you can look at.
But it,
Again, they keep referencing his record, this trial. I mean, even with the record, please read it. Read the record and see that investigators were giving shitty testimony about, like, I mean, the course of events. He tried to get in, got denied. Went, got a script, then got access. All the evidence collected against Lance were collected at the stores as purchases, as legal Washington state purchases.
again,
I mean, what are you going to do? That's what I don't understand.
when
And you don't really outline that in your brief.
when in a context of due process, it seems fundamentally unfair that on one hand, the district court says in a motion in limine, I don't want you to bring any evidence that you were in compliance with Washington state law. And on the other, allow, and the prosecutor below said, Your Honor, there's no reason for us to bring in evidence of compliance because this is a straight Title 21 charge. It's just federal law and it's illegal. But as this court recently said in Kleinman, even though they were applying that case to someone who 8 days before the rider took effect had been convicted, so it didn't apply to Kleinman. And on January 22nd of this year, a couple of weeks ago, Kleinman restated, based on McIntosh, that when the congressional rider took effect, the Department of Justice was obligated to stop spending funds in connection with charges involving conduct that fully complied with state law. And here, we have not had an evidentiary hearing to
So
determine.
when we're talking about harmless error, and we're asking you, what are you going to produce? There's nothing in your brief that suggests that you have that evidence. Why should we not rely on the record that already exists when you're not giving us anything more?
Because at this point, to apply Washington law should be left, those details should be left to the district court. The appellate court should not be determining the application of Washington law. That should be done at the evidentiary hearing with the district court. And it seems fundamentally unfair that he's barred from doing that, yet the prosecutor, as I was saying a moment ago, said there's no need for that because it's just Title 21. I referred you to Kleinman, to that specific, only to emphasize the point that had Mr. Gloor had an evidentiary hearing and then they proceeded on the Title 21 action, McIntosh provided the process by which this should happen. You look at some of the cases that were consolidated in McIntosh, we could speculate they were way beyond and outside the scope of what the state law required. But yet, in due process required that they get to have their day in court to prove whether or not they were in compliance. Here, he's barred from even bringing that. And the prosecutor conceded that below. We're just bringing Title 21 charges, Your Honor. That is what Mr. Lombardi told Judge Layton. There was any other questions from the court? Then I would like to just take 10 seconds to close to tell you that at issue here is the requirement to follow Congress's intent. In that rider, Congress enumerated Washington as a state that is trying to legalize medical marijuana. The federal government should not involve themselves in.
Yeah, I just noticed this. Like, what's up with that judge fucking checking his Twitter or whatever the fuck? And what's this guy doing? Like, it seems like they're not paying attention to her and giving her the full, effort.
Now, when they're prohibited by a congressional rider to spend funds until that evidentiary hearing is had. So we ask this court to vacate Mr. Gloor's convictions and remand for that.
This is the attitude that you see. Oh, it's just a cannabis case. So if he just stays in jail longer, no big fucking deal. It is a big fucking deal. It's a big deal to America. It's we're supposed to be better than everybody, or most, or ourselves than yesterday.
The evidentiary hearing. Thank you.
Okay, thank you, Ms. Jones. So I want to thank both counsel for their excellent arguments, and the Gloor case shall be.
Well, if you made it this far, thank you for staying for the non-sexy part of law and judicial shit, because that's what it is. It's not meant for people to take days off. It's not meant for if it's cannabis related, it's not going to be in your favor. So reach out to Lance, get a t-shirt, do what you can, spread a story out. Freelance Gloor.